Shri A. Raja.
Sir, thank you very much for the opportunity that has been offered to me to speak on this small amendment. Sir, when this Parliament discussed the 42nd Amendment, the biggest controversial amendment, it was said that the legislative competence of the Parliament cannot be questioned in the court of law. That triggered the controversy. Ultimately, it was settled down later by the virtue of 44 Amendment. The legislative capacity of the Parliament cannot be questioned in those days. That was nailed down. Now, the capacity of Parliament's capacity of legislation became a mockery through this bill. Sir, I do not know how this bill was drafted without giving any due care for the legislative competency of this Parliament. Sir, ever since this government, BJP government, came into power, the Parliament is being misused. Most of the state subjects were brought to here for enactment of laws encroaching the state power. Ultimately, state autonomy became laughing stock. Cooperative federalism becomes the laughing stock. Sir, it is a small bill, but I am not able to understand the way in which the nationalism was put up everywhere, even in the Advocates Act. The Honorable Minister says colonial law. Yes, colonial law. 1879, the provision is there. You want to repeal it. But by way of repealing, you are introducing the same section, importing the same section in the new law. What does it mean? Is it not anti-colonial or colonial law? I am not able to understand the rationality behind the government to bring this law. Again, sir, the simple reading. How a person can be listed as a tout. Explanation. I quote, the passing of a resolution declaring any person to be or not to be a tout by majority of the members present at the meeting. Who are all the members in the committee? Nothing mentioned. Who are all the members? Then, by evidence of general repute, by evidence of the general repute, evidence must be tendered by a person who is having reputation in the society. All right. The next sentence is very dangerous. Or otherwise. What happened in Article 356? On the recommendation of the governor, a state government can be dismissed on recommendation of the governor or otherwise. That otherwise was used by the president when the Tamil Nadu government was dismissed without government recommendation. Such a dangerous provision for small advocate acts, you are putting same otherwise here. How it is going to be used or misused, nobody can say. Then, come for the meaning for tout. Who procures, in consideration of any remuneration, moving from any legal practitioner. What does it mean? Money will go from the pocket of the advocate to the tout. See, this house many times discussed at length about the corruption. The Prevention of Corruption Act says, periodically it has been amended, that not only the receiver, the giver of the corrupt money also culprit under this act. He has to be convicted. The tout is going to be eliminated and given imprisonment or penalty. Does it not mean to say the person who is giving money also liable for the offense? What type of justice you are rendering to the A and B between the money is exchanged? So the very purpose of the Prevention of Corruption Act itself is defeated here by way of the way in which the bill is drafted. Sir, next one. The first time I have come across a bill that has been submitted to the Parliament, may be correct or may not be correct, I may be correct or may not be correct, that objects and reasons were not at all given in the bill. For what purpose we are going to introduce, give this amendment? whether the Bar Council of States, whether the Bar Council of India is going to be consulted when a person is going to be listed as tout or not. What will be the role of the Bar Council? Sir, Chief Justice of India, a decade ago, Justice Barucha said in the open meeting on the eve of his retirement that the 20% of the judiciary become corrupt. He made an open statement. The only problem for the litigant is, a man is having case in a particular court, whether that judge comes under 20% or 80%, how does he demark it? So you want to revamp the entire judicial system, the cleanliness, right from doubts to up to judges. But you small matter, you are not able to draft a clear law to serve the purpose. So what type of purpose is going to be served? Nothing. Sir, ignorance of law is not an excuse. That is the legal maxim. A person cannot claim, I did not know the law. But what about the society? The society, still 30% of the people are illiterate, so far as law is concerned. Again, so far as law is concerned, more than 70% of living persons are unaware about the legal system. So in such a situation, yes, you want to regularize the system of doubts, frame some guidelines, reasonable guidelines, but permit or either not permit. A healthy discussion must be there in all forums, including the Bar Council of India. Sir, suppose a junior advocate, not a junior advocate, advocate on record. You are designing advocate on record. After the examination done by the Bar Council of India or Supreme Court judges, a man has been designated AOR, advocates on record. A senior advocate designated by High Court and Supreme Court cannot be advocate on record. No, I am not. See, AOR is separate. Senior advocate is separate. Who is approaching senior advocate? Litigant? No, AOR. The role of the AOR, advocate on record, becomes almost similarity with the doubt as far as the senior advocate is concerned. So, a judicial system needs some middleman to bypass every pole in the judicial system. Whether that must be eliminated or that may be regularized with the rational application. That is the question before this House. I think that this bill is having no meaning at all because you are completely just mechanically transport a section which is available in 1879 Act to the new Act without application of mind. My only question is, what type of exercise that has been done by the government? Or what type of inference that has been drawn after this 100 years old law? Whether this provision is essential, if the provision is workable or not, practicality of the provisions has been appraised or not. Nothing has been done by this government, but everything you want to say, you want to remove the corruption in the name of Narendra Modi, starting from small bill up to big bill. So, my only thing is, don't make this parliament a laughing stock. Don't do the meaningless exercise for which the competency of this parliament is undermined. So revisit the law, take back this law, draft carefully, try to revisit, try to regularize, or try to make a system which is workable in the judicial system. Thank you, sir.
Very good.